Welcome to the HMS Management Training for the Americans with Disabilities Act, ADA. In this module, you will learn about the federal, state, and HMS requirements for ADA and your responsibilities in managing employees requiring accommodation due to a disability. Upon completion of this course, you should be able to identify the types of conditions that are defined as disabilities under the ADA, recognize situations where a person with a disability is being discriminated against, identify the types of employees and employment practices covered by the ADA, differentiate between reasonable accommodation and undue hardship, sequence the stages of the interactive process that must take place when an employee requests accommodation, identify employer responsibilities under the ADA in relation to existing and potential employees, and identify the types of interview questions an employer may not ask an applicant in relation to disabilities. Key points to remember in this module and the ADA regulations. Employee absence may be protected by the ADA. Notify or consult with Human Resources to assure ADA compliance. It is possible that ADA may coincide with other protected leaves, such as FMLA or the Family Medical Leave Act. Act to initiate the interactive process when recognizing ADA or an accommodation may apply, and always important, document any occurrences to maintain a record of your practices. Angela supervises the mailroom production, and Ralph is a member of the team who frequently complains to anyone who will hear him on a pretty regular basis about this ailment or that one. He complains so much that everyone pretty much tunes him out or waves him off, annoyed with him, so that they can get back to work. This morning, Ralph tells Angela that he thinks his sugar is out of balance and that he's been feeling off and is having a hard time processing the mail. He asks Angela, "Do you think there's something you can do to help me out?" "Help you out?" Angela says to Ralph. Annoyed and faced with a large mail out, Angela lets go with her frustrations. "Actually, Ralph, we're facing a pretty big mail out today, and we're going to need all hands on deck. Why don't we try to focus on getting this mail out completed? We can really use your help. I hope I can count on you." The incident not on her radar, Angela doesn't think any more of it until a few weeks later, when Ralph doesn't show up for work and doesn't call in to notify anyone. A representative from Employee Relations and Human Resources emails Angela that Ralph has been diagnosed with type 2 diabetes and is threatening to sue the company for failing to accommodate his disability. The Employee Relations representative asks Angela, what did she tell Ralph when he spoke of his symptoms? Bummer. Angela remembers that she really didn't pay attention to Ralph's complaints. She just figured it was another day in the life of Ralph and his long list of complaints. But apparently it wasn't what Angela thought, and the company may now be open to liability and face legal action. What did Angela do wrong in this case? Employees are a valuable asset, and as we learn about the legal requirements under the ADA, keep in mind that employee health and well-being is at the top of the list at HMS. Improper treatment of employees can lead to messy and expensive litigation, significantly harm HMS's public image, or lead to hefty fines and sanctions levied by the government. And disability and accommodation issues affect everyone. Rite Aid, one of the nation's largest drugstore chains, was charged with terminating an employee because of his disability, epilepsy, and because of a previously filed charge. It was also alleged that he had been denied promotions because of his disability. The result? Rite Aid pays $250,000 in monetary relief to the employee. The company must revise its ADA policies and provide ADA training for managers. Rite Aid's conduct violates the Americans with Disabilities Act, ADA, which requires employers to undertake a rigorous assessment of whether a disabled employee poses a safety threat in the workplace. Banner Health was charged with discrimination for denying an employee with an intellectual disability reasonable accommodation in order to perform his work duties and for firing him because of his disability. The result? Banner Health agrees to pay $255,000 in order to settle the dispute. Banner Health must also provide training on disability discrimination for managers and supervisors. Title I of the Americans with Disabilities Act requires an employer to provide reasonable accommodation to qualified individuals with disabilities who are employees or applicants for employment unless to do so would cause undue hardship. If an employer can prove that the accommodation would create an undue hardship, such as cost, impact on operations, or impact on others, then the employer may not need to make the accommodation. The Act requires that employers make reasonable accommodations that will allow the challenged employee to accomplish the job. In general, an accommodation is any change in the work environment or in the way things are customarily done that enables an individual with a disability to enjoy equal employment opportunities. The ADA definition of a person with a disability is an individual who is regarded as having such an impairment. It is an individual with a disability who has a record of such an impairment. The ADA definition of a person with a disability is an individual who has a physical or mental impairment that substantially limits one or more major life activities, including the ability to work. Limiting major life activities include sensory abilities, walking, and breathing. And the latest ADA Amendments Act, the ADAAA, expanded the definition of major life activities to include the operation of any major bodily function. The key question to consider when considering ADA requirements in this area is, does the employee's impairment substantially limit his or her ability to perform a major life activity or the essential functions of the job? Major life activities include eating, standing, bending, thinking, communicating, etc. If the answer is yes, then it is a disability. Permanent conditions like dyslexia, deafness, blindness, or multiple sclerosis do fit the ADA definition. It is important to remember, however, that determinations ultimately are based on individual analysis. Minor, temporary, physical conditions like cuts and bruises or coughs and colds are not likely to be considered a disability under the ADA. Remember, however, to check with Human Resources to make sure that a particular state does not include ailments not included by the federal ADA. According to the ADA, employers must accommodate employees or candidates for employment with disabilities. The Act requires that employers make reasonable accommodations that will allow the challenged employee to accomplish the job. In general, an accommodation is any change in the work environment or in the way things are customarily done that enables an individual with a disability to enjoy equal employment opportunities. A failure to accommodate is when an employer fails to change the way in which a job is performed in order to help a disabled employee perform in the job. A reasonable accommodation is an adjustment or modification provided by an employer to enable people with disabilities to enjoy equal employment opportunities. Employers must provide a reasonable accommodation unless it poses an undue hardship on the employer. Examples of reasonable accommodation include job restructuring, part-time or modified work schedule, acquiring or modifying equipment, and making existing facilities accessible. A request for a reasonable accommodation does not have to be formally stated or requested. The request can be made in plain English and does not have to mention the ADA or use the phrase reasonable accommodation. Once a reasonable accommodation is suggested or requested, the interactive process should begin. The employer, and that means you, the manager, and the employee engage in the interactive process. The interactive process is essentially the manager, the employee, and Human Resources opening and engaging in the discussion for accommodation, which might include a solution as far as a reasonable accommodation. Or the interactive process may mean the manager notifying Human Resources of the possible or need for accommodation and HR handling the requests from that point on. There are three things that managers should always do when an employee requests what is believed to be or could be an accommodation based upon an employee's medical condition. The acronym AID, or A-I-D, will assist in remembering the steps in the interactive process. Number 1. Acknowledge the conversation as a request for accommodation, even if that means you are the first one to use the word accommodation. Number 2. Tell the employee that you will be contacting Human Resources about the request and that either you or HR will get back to the employee regarding the request. And number 3, document your conversation with the employee regarding their requests for accommodation. In the case of Angela and Ralph, the interactive process should have been initiated when Ralph indicated that he might need an accommodation in order to perform in his job role. Angela should have acknowledged Ralph's request and let him know that she would be contacting or forwarding his request to HR so that they can address the request or notification. Angela should also have documented the details of her conversation with Ralph, including dates, times, and outcomes of their conversations or conversation. Knowledge check. Check your knowledge of the appropriate actions that should be followed in the interactive process under the ADA. Spin the wheel in the next exercise to learn more about the interactive process. Press Continue to move forward when completed. ADA requirements can have an effect on employee recruiting. Certain questions should not be asked during the pre-employment or interview process. Pre-employment questions about illness may not be asked because they may reveal the existence of a disability. Questions to avoid during interview include: how many days were you absent from work because of illness last year? Have you had a major illness in the last 5 years? Are you taking prescription drugs? Have you ever filed for workers' compensation insurance? The questions that you can ask when it comes to ADA, recruiting, and the interview process include the following. Are you able to perform these tasks with or without an accommodation? When asking this question, it can be accompanied by a copy of the job description, or a manager can describe the job functions to the individual and indicate which job functions are essential to the position. An important point to remember is that not all functions of the job are essential. Therefore, when asking this question, focus on the desired outcomes of the position and not how the job is done. The next question you can ask is, how would you perform the task and with what accommodation or accommodations? In this instance, you may ask this question if the applicant indicates that he or she is able to perform the task with an accommodation. It is important for managers to make decisions based on actual performance rather than impairments, disabilities, or speculation about an employee's capabilities. Remember, as always, some states may have specific requirements in addition to the ADA. You should check with Human Resources to make sure that a particular state does not include ailments not included by the federal ADA. You have reviewed the importance of acting according to ADA requirements during the recruiting and interview process. Continue to follow ADA and HMS standards for remembering these key points. Focus on the applicant's ability to perform the job with or without an accommodation. Do not focus on the applicant's disability. Do not discriminate against an individual with a disability. Talk to Human Resources about any concerns of reasonable accommodation request. As an HMS manager, you have responsibilities in order to comply with ADA standards and company policy and procedures. Contact Human Resources with any issues, questions, or concerns related to employee disability, accommodation request, or extended periods of absence. Recognize when there is a need for the interactive process, or when a discussion leading to or requesting accommodation might require the interactive process. Ask the employee if there is any way that you, the manager, can assist the employee in the performance of the job task if it appears that an accommodation is needed or is requested. When an employee accommodation or disability discussion occurs, document results and dates of the conversation and forward to HR to assist with the accommodation process and to maintain a record of the discussion and outcome. Follow the interview guidelines discussed in this module and avoid discriminatory practices when interviewing. And think carefully before you act or react. A hasty reaction in an instance where an employee may require an accommodation can have unwanted legal ramifications.